Thank you, Tom. Okay, thank you. This is our presentation on new workers' compensation laws and cases presented by Tom Richard and myself, Karen Korse from RTGR Law. Okay. RTGR Law does a lot of public agency and safety officer work. As many of you know, we have extensive experience in police and firefighter claims, 4850 benefits, IDRs, etc. So please feel free to reach out to us on any of those safety officer cases and any of those issues you might see there. Okay. Again, this information contained in this presentation is only for educational information and informational purposes. It is an abbreviated overview and is not to be construed as legal advice on any subject matter or a substitute for legal services. Okay. The WCAB has recently rescinded COVID emergency regulations, and we'll discuss that. Back in March of 2020, our governor declared a state of emergency due to the COVID pandemic. At that time, they suspended certain regulations in the California Code of Rules and Regulations, including witness signatures on settlement documents, regarding the electronic filing of documents with the WCAB, and the rule that established specific walkthrough hours. All of those were suspended in March of 2020, but have now been rescinded by way of an en banc decision, March 22, 2023. So what does this mean for us? It means we're going back to old style regarding CNRs. We will now need 2 witness signatures or a notary on any compromise and release agreement that is submitted subsequent to March 22, 2023. So if you have any settlement documents that are in the works, please make sure that you have witness signatures or notaries. We have asked the presiding judge at least one of the boards regarding the use of electronic signatures, such as DocuSign or electronic signature stamps. We're not getting any clear guidance, but informally among the community, we are suggesting that once again, you'll need what we call a wet signature, an actual signature. That does not mean that you cannot copy that page and submit it. It just has to be something that's not a document sign, a DocuSign. Next slide, please. Thank you. The second regulation is during COVID, the WCAB allowed service by email or fax. That has now been rescinded. You may no longer file via email or fax unless the judge specifically directs you to do so. So filing with any documents at the WCAB will be via EAMS, by mail, or you can even go in person. During COVID, also the boards were allowed to set certain walkthrough hours just to limit the amount of traffic through the board. But now the boards are now required to have their walkthrough hours 8 to 11 and 1 to 4 p.m. So if you have documents that need to be walked through, they can be walked through any day during those hours. And they are all effective as of March 22, 2023. So. Okay, I'm going to turn the rest of the presentation over to Tom Richard. He's our senior counsel, and he'll talk about the rest. Yes, I saw your question pop up. Teleconferences as of right now will continue. Trials and expedited hearings are back in person unless the parties can show good cause as to why they should be held virtually. Again, we've been given no guidance as to what good cause means for a virtual trial. So anticipate that your attorneys will be returning to the WCAB for in-person trials and expedited hearings. But for now, teleconferences for mandatory settlement conferences and status conferences are scheduled to continue via telephone.
Thanks,
Tom?
Karen. So Karen Korse is, of course, the managing partner of RTGR Law LLP with a plethora of experience in public safety and public agency workers' comp defense, and a certified specialist in workers' compensation law. Thank you for that piece, Karen. For the folks who are watching this webinar, we're doing this webinar live in front of a third-party administrator group. And they're asking the questions via chat feature. So we'll be asking, Karen will be monitoring that and asking those questions as we go through. For those of you who are attending by webinar, however, you can certainly email us anytime if you have questions that weren't answered during the course of the presentation. If you go to rtgrlaw.com and go to our contact page, you'll see all of our offices listed. And if you go to our team page, you'll see all of our attorneys. If you know your attorney, you could just click on their profile and email them directly. If you go to our contact page, you'll see all of our offices across the state of California, and you can just email through that function your nearest RTGR Law office, and the senior attorney in that office will monitors those emails and will get your question answered. So let's talk about the workers' comp laws that became effective, the important ones that became effective on January 1, 2023. One of the first was is SB 1002, which allows licensed clinical social workers to now treat under workers' compensation. LCSWs must be included in every medical provider network. That's part of the rule. However, LCSWs may not make disability determinations. So that's similar to acupuncturists, for example, who are allowed to treat, but also not allowed to make a disability assessment as to whether a person's permanent stationary, MMI, or entitled to temporary disability. The law does require a physician to refer the patient to an LCSW before the LCSW is allowed to treat. And that means a physician can include, of course, an orthopedist or a chiropractor, anyone who's a physician under the labor code. Prepaid debit cards, AB 2148 extended the deadline, which was set to expire. And this has been extended to January 1, 2024. So now workers' comp benefits can be paid through a prepaid debit card. That's something that sometimes employers pay their employees through prepaid debit card. It's for people who don't have access to banking, and there's a need for this. And if the person's already receiving their pay through prepaid debit card, it makes it much easier just to continue them instead of sending them TD checks that they can't really deposit. They can get paid through the prepaid debit card. So that's been extended another year. And there is a bill in front of the legislature right now, AB 485, that would extend that a further year until January 1, 2025. Okay, so one of the big things that happened last year is AB 1751, which extended the COVID-19 presumptions in California. Those were all set to expire December 31, 2022. And there was lots of debate on this. And what the original bill was to extend the COVID presumptions for another 2 years, which would be 2025. But that was amended, and the final version that got out of the legislature extended the COVID presumptions for an additional year. So those will, unless they are extended again, those will expire, those presumptions will expire at the end of this year, 2023. The law adds certain safety officers. Additionally, it adds certain safety officers from various state departments and state hospitals that are now covered under 3212.87, which is the safety officer healthcare presumption we've been working with. So here's a little quick summary of the COVID-19 presumption laws that have been in effect and now continue through the end of this year at least. 3212.87, of course, deals with police officers, firefighters, and certain healthcare officials. As a reminder, it has only a 30-day window to investigate and either accept or deny those claims. And of course, Labor Code Section 3212.88 is the outbreak presumption, and that one has a 45-day investigation timeframe. If the COVID claim does not fall under one of those two presumptions, so you're dealing with let's say a public agency employee who is not a safety officer, And at the time that they got their COVID, there was no outbreak at that place of employment, then they do not fall under the pre-COVID presumption, and the employer has and claims have a full 90-day period to investigate the claim. Brief overview and reminder about 3212.87, the safety officer presumption. The statute continues to require that in order to invoke the presumption, the employee must test positive using a PCR test or a similarly effective rapid test. Now, for Cal OSHA has its own rules about, if an employee tests positive, they need to not be allowed to work for a certain period of time. It's fine to use a rapid test for that purpose. It's fine to use a rapid test for really any employment purpose. But if the employee is trying to get their COVID claim covered and they don't have a positive PCR test or similarly reliable COVID test, then that arguably is a defense to whether the presumption even applies. So it's really a legal question, and that's the way the statute is written. The date of injury is the last date worked prior to that positive test. Again, that's the PCR test. The presumption extends for up to 14 days following termination of the last day worked, and the shortened investigation period of 30 days continues to apply to those COVID claims. 3212.88 is the outbreak presumption. Similarly, requires a PCR test or similar approved test to detect viral RNA. And this one has a shortened investigation period of 45 days. Of course, we know that employers are still required to continue to report their positive COVID test results. Technically, they only have to report positive PCR tests, but it's probably a good idea to report any positive test to determine if an outbreak has occurred. But again, if that employee tries to then file it as a workers' comp claim and argue that they fall under the presumption, if they don't have a positive PCR test, if their rapid test wasn't verified timely with a positive PCR test, then arguably the presumption does not apply to their claim. This is a new case that talked about the COVID workers' comp claims. Nicole Jackson versus County of Los Angeles was issued in August 2022. And what that case said was that every COVID claim needs substantial medical evidence to support causation. So I don't believe that this employee's COVID claim fell under the presumption, but the court, the WCAB upheld denial of her claim because the medical examiner that she was relying on, the QME, didn't have a specific history, just was really speculating, didn't have a specific history such as the applicant's working conditions, frequency and duration of her contacts with the public and with her coworkers, and whether the applicant's coworkers were diagnosed with COVID-19 during any relevant period. So basically the QME was just speculating and didn't know all the details surrounding her job versus her off-work exposure, her family, who she lived with, what she did outside of work. So the QME was really speculating, the WCAB found. And the burden of proof, if there's no presumption, the burden of proof is on the employee. So if the employee shows up and doesn't have convincing medical evidence, then the employee loses. All of the presumptions are rebuttable. So we know for all cases, the employee has to produce convincing medical evidence. For the presumption to apply, they have to have a positive PCR test or similarly accurate test. If the presumption applies, if they have all that, they've checked all those boxes, and you're dealing with a presumption claim, they're still rebuttable. You can still defend a COVID presumption claim, even for public safety officers. And that's the rebuttal is included and cited there for each of those statutes. 3212.88 is a little bit more specific as to what the rebuttal evidence can include. And that is includes but is not limited to evidence of the measures in place to reduce potential transmission of COVID-19 in the workplace and the employee's non-occupational risks. So those are really the two areas in any COVID case we want to look at evidence-wise. Was the workplace unsafe, or was the workplace actually, being kept safe in terms of COVID? And one of the big things is making sure that anyone who has COVID isn't at work, right, or is sent home. And what are the non-occupational risks that that employee is facing? So we have, many police and fire cases where I have one sort of classic case. There were two with another in our office where a police officer went to Las Vegas for a bachelor party. This happened twice, two different agencies. A Las Vegas bachelor party, everybody in the bachelor party got COVID, and he comes back and, of course, files a workers' comp claim. He had been at work within the 14-day window, but also subsequently was at this bachelor party in Vegas where everybody got COVID. We were able to use that as evidence to rebut the presumption and prevail in those cases. So the COVID presumptions are rebuttable. Again, a quick summary of what we're looking for to rebut that presumption: good remedial measures in place at the workplace, insufficient exposure to COVID at work, which means to a COVID case at work, which means exposure to an employee or a member of the public, basically for more than 15 minutes in a 24-hour period, who is positive for COVID-19, or contemporaneous non-work related risks, like a housemate that had COVID at the same time, or attending a bachelor party where people had COVID. Okay, so that's the statute. Another thing that happened, this happened on February 3rd of this year, is Cal OSHA passed their COVID-19 non-emergency regulations. What that means is Cal OSHA doesn't consider COVID to be an emergency anymore. It's a non-emergency. But it's still, of course, an epidemic, a pandemic, and it is still covered under the Cal OSHA regs. Of course, these rules apply to employers, not to claims administration, but I think it's important to know these because this information is relevant to the defense of any COVID claim. The hyperlink there is to the frequently asked questions page that Cal OSHA put together, which is quite marvelous because it is written apparently by not lawyers, because it's written in fairly plain English and it kind of makes sense. So I recommend the frequently asked question page for any California employer to visit if they have a question about that and whether they're in compliance. It defines close contact. So for claims purposes, why this is really important is because these regulations define what is close contact. So when we're rebutting a COVID presumption claim or really defending against any industrial COVID claim, whether that employee had close contact with another employee with COVID, what is close contact? It's defined here in these Cal OSHA regs. So that gives us the answer. And it varies depending on the size of the workplace and how big the building was and the frequency and duration of that contact. It also gives the main requirements for a COVID prevention program that every employer in California must have, and addresses return to work after positive testing, which is another one that's important. So it defines the infectious period when someone can be allowed to return to work. And in for example, if the person subsequently tests negative with a simple take-home COVID test, then they can get back to work sooner.
Tom, we have a question regarding the rebuttal. If there is no known positive exposure at work, would an employee's failure to provide non-industrial exposures potentially support a rebuttal?
Failure to, failure to respond to an inquiry or have their statement taken on that topic, I'm guessing.
That would be my understanding of the question.
Then I would say yes, because you can assume that there's non-industrial exposure, and you can always deny a case for failure to cooperate with the investigation. So I would say, even if their failure doesn't really go to proving one way or the other whether there was non-occupational exposure, their failure to respond to a valid and reasonable investigation question is a basis to deny the claim.
And yes, that was clarifying their failure to respond to non-industrial exposures, like not telling you they went to the bachelor party in Las Vegas.
Yeah, I would, or if they just refuse to answer, that's not unusual, where the claims will ask, do you have anyone in your family who's had COVID? Have you had exposure to anyone outside of work? And they refuse to answer. It's like, well, it's none of your business, whatever. I think that's a valid, in a COVID, if you can't ask that in a knee injury, right? That wouldn't be valid. That would not be a basis to deny it, but it's certainly a valid basis to deny a COVID claim because that's a failure to cooperate with the investigation. So next big thing that happened last year is the See's Candy case. This is a very important case for California employers. We're covering it today for claims audience because it's important for you to know this as well, because employers are going to bring this up, but we're going to go quickly through it. It does create a lot of exposure to California employers. So it could represent a sea change in California law with regard to workers' comp. In the See's Candy case, Matilda Eck worked for a See's Candy's assembly and packing plant in Southern California. She contracted COVID-19. She filed a workers' comp claim. When she got the COVID-19, she was sent home. She convalesced at home. A few days later, her husband and a daughter became ill with COVID. Unfortunately, her husband, Mr. Eck, passed away from the illness, and it is claimed that he contracted the illness from Mrs. Eck, who, of course, in turn claims that she contracted the illness from work, hence her workers' comp claim. The family and the estate of Mr. Eck filed a civil wrongful death lawsuit against See's Candy. So that means See's Candy had both a workers' comp claim by Mrs. Eck for her illness, and a lawsuit by her husband or late husband for his death from that same illness. So the plaintiffs in that case, See's Candy, the plaintiffs, the Ecks, argued that the assembly environment wasn't safe. People were working too close together. There wasn't sufficient mitigation evidence. That's what they were claiming or mitigation efforts. That's what they were claiming in their lawsuit. And that this increased the risk of COVID-19 being transmitted to their employees and then in turn to their employees' families. So the defendant, See's Candy, filed a motion to dismiss this. And they did that saying, this is exclusive remedy, that this lawsuit by the family of Mrs. Eck cannot be brought forward because of what's called the derivative injury doctrine, which is part of the exclusive remedy rule, which basically means you can't both sue your employer for an injury or illness and file a workers' comp claim. And if you fall under the Workers' Comp Act, you only get to file the workers' comp claim. So that was the defense. Please, judge, dismiss this case. The trial court had a hearing, and the trial court did not dismiss the case. The court rejected our common understanding of what qualifies as a derivative injury and found that Mrs. Eck her injury, employee's injury, was irrelevant to the late Mr. Eck's claims because that injury is not the injury upon which plaintiffs are suing. They're saying the judge in that case said it was a separate injury. This went to the California Court of Appeal. Defendant See's, of course, appealed that to the California Court of Appeal, asking them to overrule and grant the motion to dismiss. However, the Court of Appeal agreed with the trial court, found that the derivative injury doctrine does not apply. There's the citation for this case. It is a published California Court of Appeal decision, which means it is the law in California. The holding in the case, or what the court basically said, was that take-home COVID, so you take it home from work, contracted by a non-employee as a result of contact with employees who got COVID at work is a separate physical injury and therefore not derivative of the employee's injury. Although, as I think about it, I think that if the employee gets COVID, transmits it to this non-employee third party, that the second injury derived from the first injury. So why doesn't it fall under derivative injury? Well, the Court of Appeal said it doesn't. And that this workers' comp exclusive remedy is not applicable in those situations to injured family members, roommates, anyone else who claims they got the illness from that employee. So the decision exposes California employers to really untold lawsuits from individuals and estates in that situation. Anyone who can claim to trace their COVID back to a family member, friend, neighbor, stranger they meet on the street who happens to be working somewhere when they got COVID. So this had a long and circuitous route up to the California Supreme Court, and these are the two questions which are now pending in front of the California Supreme Court. Does take-home COVID lawsuits barred by the derivative injury doctrine? And even if they aren't, does the employer owe a duty of care to everyone that their ill employee comes into contact with outside of work? So this California Supreme Court is addressing those questions right now. That's for those of you who are interested, that's the Supreme Court case number where you can, and hyperlink there on our PowerPoint, which will be on our PDF, which I should mention, we will make a PDF version of this available for anyone who would like it, whether you're attending now and live with us, or if you are watching this webinar later on, you can always reach out to us again through our contact page, get a copy of the PDF of this PowerPoint. And as of March 23, 2023, the Supreme Court is now scheduling oral arguments. So we will see probably in the next few months what the California Supreme Court does with this. Okay, the other big thing that happened, if that wasn't enough, in 2022 was SB 1127, which is the law that changes California police and firefighter presumptions, the rules affecting those claims. And we're talking now about police and fire presumptions other than COVID-19 presumption, right? We're talking about all the other presumptions that apply to California's firefighters, and police officers, and deputy sheriffs, and others. So it was signed into law by the governor after many amendments, and I'll spare you the long detail of how originally this was a bill that would have changed all workers' comp cases to a shorter investigation and denial timeframe, but in the end, it just applied to police and fire claims. So what the law does is it raises the TD cap for certain cancer injuries, and it shortens the investigation time limit for all presumption claims. So raises the TD cap. So SB 1127 changes 4850 TD caps for police and firefighter cancer injuries under Labor Code Section 3212.1. So first thing to make sure is that you're dealing with a cancer that falls under 3212.1. That narrow class of employees, and that it is a cancer claim. If it is, then that employee potentially has 240 weeks of 4850/TD available to them rather than 104 weeks, which applies to all other presumptive injury claims and all other claims, right? There's a 2-year TD 4850 cap. We know from the Knittel case, which came out a few years ago, that the 2-year cap, the 104-week cap applies to 4850 as well. So it's common understanding that police and firefighter cases have up to a year of 4850 followed by up to a year of TD. But now, if that cancer claim is filed because it occurs on or after January 1, 2023, then that cancer claim may have an additional over 4 years of additional total benefits. So first, I want to make clear, and this seems to be the consensus that we are all agreeing on, is that the 4850 cap is still 52 weeks because then nothing changed in Labor Code Section 4850. So 4850 still caps at 52 weeks. But what happens is the TD that picks up after the 4850 ends on week 53 would normally be for another 52 weeks, but for cancer cases, it'll be 188 weeks of TD potentially. So this is a situation where, some police and firefighters may, I'm not saying that all of them try to run out their TD with until the very bitter end, but some of them may. And in a cancer claim, we want to be mindful of the fact that we could be on the hook for a TD for over 4 years, 40, 50 plus TD for over 4 years. So it's worthwhile to be mindful of that and see what can be done to end that, to get that person declared MMI or retired out on an IDR, or whatever can be done to stop the payment of TD and move this person along. Okay, the other thing that SB 1127 does is it limits the denial timeframe. It was originally proposed it would have limited all workers' comp claims from 90 days to 60 days to investigate, and that would have, thank God that was killed in the legislature. It would have been quite burdensome for California. Instead, it limits the investigation timeframe for presumption claims. Only 90 days remains for all other claims. So the new deadline for safety officer presumption claims is 75 days, and it applies to all presumptive injuries covered by 3212 through 3212.85, and then picks up again at 3212.9 through 3212.13.2. What's happening here is they're just carving out the COVID presumptions. So here's the presumptions that are covered under this new 75-day investigation timeframe: hernia, heart trouble, pneumonia, cancer, PTSD, tuberculosis, MRSA, meningitis, and low back injuries for some police officers. So all the presumptions we're used to dealing with. So the biggest questions we've been getting about this 75-day timeframe, in addition to the question of how on earth can we possibly get such a claim investigated and reasonably denied within 75 days, the other big issue is when is it effective? What injuries does it apply to? The law did not become effective until January 1, 2023. Therefore, it only applies to injuries occurring on or after January 1, 2023. Nevertheless, if I think we're out of that 75-day window at this point, but if for any reason the date of injury is prior to 1/1/23, for example, you have a late reported or a cumulative trauma claim, for example, which is, the doctor is saying the date of injury is back in 2022, I would still deal with that as a 75-day window. When in doubt, deny those claims within 75 days. This, as we all know, 75 days may be unworkable because 90 days sometimes is unworkable as far as getting out everything done that you need to get done to investigate a claim. Because a lot of these claims, you need medical legal input in order to make a sound decision about compensability. At the same time that this statute became law, or right around the same time, the administration passed Rule 31.3E. This became effective on February 2nd, 2023. And Rule 31.3E extends the initial QME exam timeframe from 30 to 90 days. So what that rule did is it allows QMEs to take up to 90 days to set their initial exam. So if you don't have a QME exam even taking place until 80 days after claimed injury, how on earth can you deny the case or reasonably investigate it or get a medical legal opinion on it within 75 days? It's impossible. Even if the exam does take place quickly, let's say the examiner is, has availability and it can easily take over 90 days to receive the QME report, depending on when the doctor sets it. So under this law, it's possible and probable that provisional denials or conditional denials, however you want to frame it, of claims, despite due diligence, maybe have to be issued because of a lack of a QME exam or other investigatory reasons. It's a quote was asked, what if the QME, writes a report, but you need a supplemental report, and then you're set running up against the 75 days. I mean, those are all valid reasons to deny a case, until you get that final opinion. If the exam can't take place or you haven't received the report, valid reasons to deny it. The only time it would not be valid under these circumstances is if there was some delay on the part of the employer or on the claim side in getting the QME going. So I think that, being diligent about getting the QME documents out, which you all do, with the delay notice, that makes just a ton of sense because it gets, we're trying to get it done, be diligent, and all of these presumption claims to do 3-point contact, to get statements, to subpoena records, or get a release to get the employee to release those records and go after those records as quickly as possible. So, for example, in a cancer case, you almost always in a cancer case have to have a biopsy from some doctor. It's not enough to just have a claim form that says cancer or a letter from opposing counsel that says my employee has cancer, my client has cancer, or a treating physician that says even lists a diagnosis. Those cases really require a biopsy. Maybe if the treating doctor is referring to a biopsy, and if they are, then subpoena those records or get a release for those records, and let's see the actual UCSF or Kaiser Permanente biopsy report that says this is cancer, right? Read by a radiologist or written by an oncologist. Then it truly is a valid claim. It's all, as long as you're doing all that stuff, denying it because the 75 days hits is not going to be in bad faith, not going to be unreasonable. We're going to talk more about that in a moment. Okay, so before we do that, let me just show you this slide, which I think is handy because it has the new 4 denial claim timeframes. For those of you who can remember all the way back to the year 2019, before COVID-19, I know it's all like a blur in between now and then, but back in 2019 and going back about 100 years in California workers' comp, we had one investigation timeframe, which was 90 days for all claims. So as of right now, and at least until the end of this year, we have 4 investigation timeframes. So 30 days for police officer, firefighter, healthcare, COVID-19 claims, 45 days for COVID-19 claims during an outbreak, 75 days for all other safety officer presumption claims, and 90 days for all other workers' compensation claims that don't fall under those other 3. So what can I say? Good to have computer calendar reminders. So $50,000 penalty. I know this has gotten a lot of interest by applicants' attorneys and by concerned claims folks. Worried. We've already been getting threatening letters from applicants' attorneys who shall remain nameless, who are, anytime there's a presumption claim or threatening a $50,000 penalty. So let's drill down and see what the law really says. SB 1127 says that it raises the cap for an unreasonable denial of any presumptive injury claim. So that's hernia, cancer, heart, PTSD, meningitis, any presumed injury that is unreasonably denied, the amount of the delayed benefits. So for example, if 4850 is delayed or medical treatment is delayed, is increased by 5 times. So instead of 25% under 5814 for an unreasonable delay of benefits in a regular case, this is a 500% increase, 5 times, up to a cap of $50,000. Originally, it was proposed to be $100,000. That was changed before it became law. This new penalty provision for police and fire presumption claims denials applies to all dates of injury, regardless of whether the injury occurred before the enactment of 5414.3. So does that mean that applicant attorneys can go fishing for penalties on claims that were denied a year ago? Potentially, they can. Haven't seen a lot of that yet, thank God. Hopefully they're not watching this webinar where I explain it. The penalty, however, is not automatic. So it doesn't mean that just because you deny a presumption claim that all of a sudden you get socked with a $50,000 penalty. It only applies, first of all, to unreasonable conduct, and the statute does not change many years, decades of cases that define what is unreasonable when it comes to denying a workers' comp claim. I know that the audience attending this webinar far too diligent to just deny a claim because they didn't get around to investigating. That would be unreasonable, right? It would be unreasonable to deny a claim because you didn't bother getting any records, you didn't bother reviewing any medical treatment reports, you didn't bother starting the QME process, you didn't bother interviewing the employee. If that's all done and there's still questions pending, it's not unreasonable to wait for a QME report to weigh in, or wait for an AMU report to weigh in, or wait for subpoenaed records to come in, or whatever it takes to conduct a meaningful investigation. And it's not unreasonable if there's genuine doubt. That's what the cases say. There's genuine doubt. Doesn't mean there's proof beyond a reasonable doubt. It doesn't mean there's clear and convincing evidence. It doesn't mean that there's even evidence by a predominant means to prove that it's not a work-related injury. It just means that you have genuine doubt as to whether it's a workers' comp claim or not, a compensable workers' comp claim. And if you have genuine doubt and you have done what you can to investigate it, then it is the burden of proof is on the employee still to prove injury, and it's not unreasonable to deny those cases. That's what the case law continues to say. Additionally, even if the denial is unreasonable, the penalty may not apply if there were no benefits delayed. The penalty only applies to the amount of benefits that are unreasonably delayed or denied. So if no benefits were owing, then there's nothing to attach a penalty to. So remember that one, because it's important, because in a lot of these police and fire cases, there may be no lost time for work for the injury, right? And there may be some medical bills, maybe some initial medical treatment, but those may have been paid during the delay period. The employee went to occupational health and the employee did this and that, and you pay those bills during the delay because it's under the $10,000 cap. So you end up having paid the benefits that were due. There's no lost time, so no 4850 due. You deny the case, applicant attorney says, oh, penalty, you unreasonably denied this claim. It's a presumption claim. Yeah, but what benefits did we delay? And if you didn't delay any benefits, then there's nothing to attach. The multiply times 500% up to a $50,000 penalty cap. Let's talk a little bit more about what is an unreasonable denial in the context of safety officer presumption claims. So if the defendant, here's a case, County of Sonoma versus WCAB, where the defendant was relying on a medical legal report in a heart case, a heart presumption case, where the examiner overlooked the presumption and just addressed whether the heart problem was more likely work-related or not. So the doctor didn't even address or consider, maybe wasn't familiar with the heart presumption. If you get such a report, obviously we want to turn around and ask the doctor, hey, you got to address the presumption, or but in this case, instead of asking the doctor to issue a supplemental report or address that, the employer decided to rely on that opinion, and that was grounds for a penalty. That was an unreasonable denial. Another example is denial of a heart presumption claim based only on pre-existing heart disease or congenital defects or genetic factors. those are all probably unreasonable bases to deny a heart claim, because you can't, under the statute, the anti-attribution clause and the heart presumption, you can't base the denial on pre-existing factors. So the fact that the employee had longstanding heart disease when he joined the police force or when she became a firefighter is not a basis to deny the case. Here's the heart, since we're talking about the heart. And I have this picture of the heart because it's important to, you don't have to remember all this, but it's important to reference it when you have a heart claim, especially one that isn't clear cut like a heart attack, but where you have something happening in the circulatory system, which may not necessarily be the heart. So you see in this image that there's the right pulmonary artery, that big blue guy that's going up on the left side of the screen, and then the veins and such running off of the heart. Once they get past basically where they are in this picture, then they are no longer part of the heart. They're part of the circulatory system. So we've had cases where the employee develops an abnormality in the artery or an artery or a vein far enough away from the actual heart muscle that the doctors have agreed, or the judge has found, that doesn't fall under the heart presumption because it's not actually heart trouble. It's vein trouble or artery trouble elsewhere in the body. So just a little something I look at, and anytime you're dealing with a alleged heart trouble presumption, and it's not something that falls squarely within this muscle. This is the heart, and it has to be heart trouble. It's not a circulatory system trouble presumption. It's a heart trouble presumption. There is no strict legislative or judicial definition of heart trouble, but we know for sure it includes heart attacks because, by its very nature, that's the heart. A heart tumor will fall under the presumption, and a heart tumor, by that I mean something that's a tumor that develops on this organ, not a tumor that develops lower down or a tumor that develops higher up from the heart. A aortic valve disease constitutes heart trouble, and the aortic valve would be here in this image. It would be right there in the heart. So aortic valve disease constitutes heart trouble. And by the way, in these slides and the Herforth case that's cited there, I'm not sure if the citation may appear later on, but I'm trying to give you all of the citations for these cases in case it comes up with applicant's attorney, especially the ones where things do not constitute heart trouble. So LVH is definitely heart trouble, but LVH, there's a fine line between what is and what is not LVH, and it's something worth exploring with the doctors, because some doctors, have different opinions as to the measurement in the left ventricular, what actual measurement of the left ventricular constitutes this disease or not. So that's also something worth considering, because if it's not enough of a thickening of the left ventricular wall, then it does not fall under this disease classification, and therefore it's not heart trouble.
Tom?
So, yes.
We have a question regarding these heart trouble. What about aortic aneurysm? Will that depend on the location?
Beep, beep. So aorta, it depends if the aneurysm is in the heart, or is the aneurysm of the aorta further down or further up from the heart. So it doesn't necessarily be defined as part of that heart muscle. So that, I spent a couple of hours in a deposition, maybe not a couple of hours, felt like a couple of hours in a deposition with a cardiologist, actually just an internist who was a QME. I wish he was a cardiologist, but he was just an internist. And I was deposing him on this very question, where the the aneurysm that the person developed was, really further away from the heart, but still in the circulatory system, obviously. And that became a whole fight over whether this constituted heart trouble or not. Now, the opposing counsel is a pretty reasonable person, and we ended up settling that case. We didn't go to trial, so I don't know what the trial judge would have done with that argument, but we ended up settling it at I thought a pretty reasonable settlement, because it was a valid argument as to whether the aneurysm was part of the heart or not. If it's not part of the heart, then it is not a presumed compensable claim. And if it's part of the heart, it is. So I think that's what we're looking for, is where exactly is the aneurysm located. Okay, so the cerebral stroke is not heart trouble unless the cerebral stroke has caused in part by a heart defect. Then it will be industrial. If it's arteriosclerosis affecting the peripheral vascular area, right? So this is the vascular circulatory system further away from the heart. Arteriosclerosis elsewhere in the body. And an abdominal aorta, going to that last question, an aorta in the abdomen, for example, is not heart trouble, absent a connection to some cardiovascular disease, absent a connection to actual heart trouble. So if you have the person has a bad heart, has a heart disease, and it is causing all this arteriosclerosis, or it is causing aortas elsewhere in the body, those may be compensable consequences of heart trouble. But just having arteriosclerosis in the peripheral vascular system, or just having an abdominal aorta or an aorta elsewhere outside of the heart, does not constitute heart trouble. It constitutes cardiovascular problems. This is the Bennett versus WCAB case. Hypertension alone is not heart trouble. Hamilton is a really good case. It's a California Court of Appeal case. And for those of you who have trouble sleeping, I recommend reading it at night, and it'll put you right to sleep. But if you find yourself awake and you're reading it, it really covers the heart presumption in great detail, and it is binding legal authority. It was done back in 1979, but they really did a good job, and heart trouble hasn't changed that much since then. And that really is the case that established that hypertension alone is not heart trouble. If the hypertension, however, is caused by coronary heart disease or another cardiac abnormality that is manifest on testing, then it is heart trouble. And that's the Musnick case, another seminal Court of Appeal decision discussing the heart presumption. So I've had cases, by the way, with hypertension where the QB examiner has said the person has hypertension, it's caused by work. Okay. It has not yet caused heart trouble, but it will cause heart trouble. This person will develop heart disease, medically probably develop heart disease. And that we've gone toe to toe on those cases and prevailed that just because someone might develop heart disease in the future, just because they have what the doctor claims to be work-related hypertension, that does not fall under the presumption. So this is not unusual, where you get a firefighter or a police officer who goes in for an annual physical, and the doctor reports that tachycardia is detected, or maybe this comes up in their own personal doctor's office, that maybe they just experience something that they consider to be heart trouble, and it turns out they had 2 isolated incidents of tachycardia, and then it goes away. There's no recurrence, and it's basically considered by the emergency room doctors to be a non-cardiac event. And that's the Andrews case, which said that that is not heart trouble. So isolated incidents of tachycardia don't constitute heart trouble, because what tachycardia is a symptom. And heart trouble is talking about basically end organ damage, something that has damage to the heart and is diagnosable. This is not this person had an otherwise healthy heart. He just experienced this symptom, and it was isolated, and didn't reoccur. So no heart trouble. A non-industrial liver condition developing during the course of employment is not heart trouble, even though it may affect the heart. So this is the reverse of heart trouble or cardiac issue that then affects other parts of the body, which can be compensable consequences of the heart trouble. If you have another part of the body, in this case, the liver, that is directly producing trouble to the heart, right? And other organs in the body and other body systems, that in the Fremont case was held not to be heart trouble because it's the reverse. It's a non-industrial liver problem, hurting the heart.
Tom, one more
Yep.
question about what actually invokes the presumption. Does coronary artery disease invoke the presumption?
Probably, because coronary artery disease. So I would say it depends, because it has to be, as long as it's affecting the heart directly and there's some sort of measurable defect in the heart, then yes, it will be industrial. So that's the question you're always going to be going to the QME, the treating doctor, to answer is this arteriosclerosis? Is this coronary artery disease? Is this, whatever the heart issue is it affecting the heart itself, or is it something that's peripheral? Even if it is heart trouble, you may still be able to rebut the presumption. So don't forget that what we've been talking about so far is does it invoke the heart presumption? So now we're asking, does it, even if it does invoke the heart presumption, can you rebut it? And the answer, yes, you can rebut it. It takes very good evidence to rebut the heart presumption, but it certainly can be done. One way to rebut it is if the sole cause of a heart attack is a contemporaneous non-work related event, such as off-duty strenuous jogging, then it is not compensable. Now I've cited two cases for you because this is a hot topic with certain applicants' attorneys. Johnson case is a court of appeal decision. That's legal authority. And Robinson was a workers' comp appeals board decision. In both those cases, Johnson, I think, is the one that dealt with off-duty strenuous jogging. And that led directly to the heart attack. And the court found that that was enough to rebut the presumption. No question that the presumption applied because the off-duty jogger was a employed police officer, I believe. And of course, wasn't on duty at the time, but he was working at a police department and he had a heart attack, right? Presumption applies. But the employer was able to rebut the presumption because they showed that it was, the medical evidence showed that it was directly related to this very strenuous off-duty jogging. Now, where this comes up a lot is where the applicant's attorney will claim that, or the employee will claim that, yeah, I was off duty and I was doing this, tough mudder race, or I was doing this, crazy up a mountain run, or whatever. I was running a marathon. I was doing a triathlon. I had a heart attack. Race car driving. I had that case. I had a heart attack. Dirt bike riding. That happens. What they do is that some of them will claim that, well, I was only doing this strenuous jogging, especially if it's a physical activity, like a physical fitness activity. I was doing this to stay in shape because I'm on the SWAT team, or I was doing this to stay in shape because I'm a firefighter. I have to be able to, kick indoors and stuff. So that's where the argument turns. There are cases, one of them out of Sacramento, where I think it was a police officer had a knee injury while playing basketball off duty. And the Court of Appeals said he claimed that the knee injury was work related because he was playing basketball in order to stay in shape to be a police officer. The Court of Appeals said, no, that's off duty. That's an off duty recreational activity. It is not, and that is not a close enough nexus to the employment. There was, by the way, that employer, that police department had no physical fitness requirement that you have to exercise outside of work to stay in shape. So the defendants were able to win that case. So that's all that comes into play when looking at this defense. Postpartum cardiomyopathy is non-industrial because it's a medical condition, not work-related heart trouble. proof that a non-industrial pancreatic cancer caused blood clots leading to a stroke and heart attack rebutted the presumption in the Blue Cross of California versus WCAB case. Okay, I want to switch gears to the cancer presumption. I don't see any questions in the chat box, so we'll go right on to the cancer presumption.
Actually, Tom, we did have one question,
Okay.
which may also kind of go with the cancer presumptions here. It goes back to the the increased MMI and, or excuse me, increased TD times. And I think that the question is, how do you get a doctor to get someone to an MMI status due to the insidious nature of some cancers? What suggestions are there to the doctor, getting the doctor not to say, well, they're going to be TD forever because of the nature of their cancer, it's just going to progress?
So that's a great question. We can spend a lot of time, and mostly that will happen in cancer or similar disease processes. They're entitled to render that opinion. There's a case on point, which is slipping my mind, but there's a case where you can do the stipulation deferring PDs almost indefinitely while the insidious disease process, continues. And in that cancer situation, it is entirely possible that you'll find yourself with a QME and a treater who will not make the person MMI because their cancer keeps changing, going into remission, coming back, changing, and there's different treatments that are being tried, and so it's too soon to tell. And so that's a situation where you may be running up against 240 weeks of TD. And that, I think, is where the employer needs to take a serious look at the Fair Employment and Housing Act and whether it is this continued leave of absence under workers' comp, this continued time away from work is a reasonable accommodation to make to that employee, or whether the employer can, for example, go through the interactive process and secure a fitness for duty evaluation from a different doctor, perhaps an actual oncologist, to opine whether this person will ever be likely to return to work. And if not, then they can begin the IDR process, because obviously we're talking about a situation where they will have already paid 52 weeks of 4850. And, without going to too much of a sidebar regarding CalPERS and IDR and the interactive process, I just want to offer that as an alternative route in that situation, because you may not, in a cancer case, I have seen where neither the treater nor the QME or even an AME will make the person PNS, and we'll just say that it's, it's too soon to tell. We may not know for years. That's a situation where you need to switch gears, the employer needs to switch gears in order to fill that position and look at the interactive process as an alternative to this ongoing indefinite leave of absence from work. Okay, rebutting the cancer presumption, because we're really focusing today on rebutting it. What evidence in the context of this $50,000 penalty? That's why we're talking about these. So there's a lot to be said about the cancer presumption, which we're not going to go into. We're really talking about what's reasonable for a basis to deny a cancer claim, a presumed compensable cancer claim. And the rebuttal of those cancer claims brings up the situations where it is reasonable to deny it. One situation is if the cancer, well, first of all, the cancer presumption is rebuttable if the defendant can establish the primary site of the cancer and affirmatively establish that there is no reasonable link between the carcinogens that they were exposed to at work and the cancer. So the defendant must produce scientific evidence, convincing medical legal evidence that a specific carcinogen is not reasonably linked to a specific cancer. So for example, the best example really is melanoma on the mid-back. We've had a couple of cases where the person develops a skin cancer on a part of their body which would not be exposed to sunlight. The type of cancer is one that is almost certainly caused only by sunlight exposure or UV light through tanning beds. And because that way the arguably work could not have contributed to that the development of the cancer at that site. That is a basis to rebut the presumption. Oh, another basis to rebut the cancer presumption is the latency defense. This is something that really is relevant when you're dealing with a short-term employee, for example. Defendants can rebut the cancer presumption by establishing that there is a latency period and that the employee's employment doesn't fall within that latency time frame. So, for example, medical studies suggest that solid tumors have a minimum 10-year latency period. Some of them have longer time frames, and that is the time between exposure to the carcinogen at work or wherever and the manifestation of the cancer. And if the officer or firefighter has not been on the job in that situation for 10 years, then the presumption may be rebutted. And that there's a case called Dennis Joy versus WCAB. That's exactly what happened. AMEs or panel QMEs may offer differing opinions as to the latency period or a particular type of cancer. We want to make sure that the AME or QME is actually citing medical evidence, medical journals, because we need to rely on scientific evidence. So we want the AME or QME to bring in scientific evidence, cite to medical journal, published medical journals, peer-reviewed evidence regarding the latency period, and then tie that into the person's time at work. If it is a medical legal question requiring medical expertise, and if there's genuine doubt as to the liability for benefits, there should be no penalty for delay or denial pending receipt of medical legal reports addressing these questions, so long as there was no delay in the investigation of the claim or the initiation of the QME process. There's a case that is what the WCAB said with regard to genuine doubt. Wow, okay, so we're kind of coming up to the end here. We talked about those bills which became law, and these are 4 bills which we think are kind of interesting that are being considered. These again this is not law. These are just being considered by the legislature, or these were last time we checked. One would add dispatchers and EMTs who are not firefighter EMTs to the PTSD presumption. So some agencies use EMTs who are not actually sworn safety officers, and a lot of agencies use dispatchers, and this would bring them both into the PTSD presumption. It's AB 579. That one's worth watching. AB 1107 would add PTSD to certain State Department employees, correctional officers mostly. AB 1156 would create a presumption for certain hospital workers, and this one's pretty broad because for certain hospital workers, it would include infectious diseases, cancer, musculoskeletal injuries, PTSD, respiratory diseases, and including COVID-19, for those workers who have direct patient care. So it would basically broaden for hospital workers who have direct patient care, all of the presumptions we're used to, or many of the presumptions we're used to applying to police and fire. AB 1145 would add a new labor code section creating a PTSD presumption for certain state nurses, psychiatric techs, and other medical and social service specialists. So those are 4 worth watching for public agencies and the state regarding their employees. Okay, thank you for watching this webinar, and I hope it was informational for you. As we like to remind everyone, our firm, RTGR, specializes in public agency defense. We, I think, are the only statewide workers' comp defense firm. Don't take my word. I'm not 100% sure about that, but I think we're the only one that focuses predominantly on public safety and public agency defense, including dealing with the education code and school districts, 4850 paid leaves of absence, IDRs, CalPERS, 1937 Act, entities, police and firefighter claims, risk pools, excess insurance claims. That's where cities have to fight with their excess carrier, or not fight, cooperate with their excess carrier, carve-outs, ADRs, all of that fun stuff that public agencies deal with. That's where we enjoy practicing. And here's, if you have questions that you're attending this webinar, watching the recorded version, here's where you can send your questions that we didn't get answered in today's program. You can just email your nearest RTGR Law office. You can also visit our website and follow us on LinkedIn. We usually post all of our legal updates on LinkedIn as well. So thank you. I hope you enjoyed this, and I will end the recording if I can figure out how, and